Sir, you're Ernest Sinnett Senior,
Yeah.
and Mr. Sinnett was previously in court and entered a pleas of not true to counts 1 and 2 in a motion to revoke probation. And so Ms. French, does the state have witness with regard to those counts?
Yes, Your Honor, we do. The state would call Sarah Simon.
Good morning, Ms. Simon. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Thank you, Your Honor. Ms. Simon, are you employed with the Jefferson County Adult Probation Office?
Okay,
And in what capacity is that?
I'm a probation officer and I supervise the sex offender case.
All right, and as someone supervising the sex offender caseload is Ernest Joseph Stinnett Senior, one of your probationers.
He is.
And how long has he been supervised by you?
Since February of 25.
February of 25. During that time, the past year or so, has he been required to participate in sex offender group counseling?
He has.
And has he done that?
He has, but he has been discharged twice unsuccessfully.
And can you tell the court why he was discharged twice unsuccessfully?
The first time he was ordered to take a sexual history, the sexual history polygraph with Julie Ayala. He did not show up for the polygraph, nor did he call Miss Ayala about not attending. He's been very adamant about his excuse me, I'm sorry. About not being guilty for his offense. He doesn't accept responsibility for his behavior. So he was ordered to attend with Mr. Simon, and Mr. Sinnett was aware that he was going to have to take another polygraph with Mr. Simon as well. I advised him to set aside funds for that polygraph since he cannot afford it with Miss Ayala, and he did not do that with Mr. Simon. He was discharged for continuing to deny responsibility for his offense behavior and did not adhere to his financial obligation for treatment services.
So what you've testified to with regard to any failure on Mr. Sinnett's part are both condition 28 as alleged and condition 29 as alleged in the MTRP.
Yes, sir.
And just to be clear, is Mr. Sinnett here in the court today?
Yes.
And can you identify him by an article of clothing he's wearing for the court?
He's wearing a black sweater.
I asked that the court, I'm sorry, I just drew a blank.
He's already, I've already asked him his name, and he
Okay.
has stated that he is in fact Mr. Ernest Sinnett Senior.
Okay. This is a 10-year probation term, is that correct, deferred?
Yes, ma'am.
And did you prepare the PSI?
I did.
And ask the court to take judicial notice of the PSI?
I will do that.
In PSI, you talk about Mr. Sinnett denying this offense and refusing to accept responsibility, correct?
Yes, ma'am.
But yet he's on probation because he pled guilty
Correct.
to this offense.
Yes.
And are you aware that he also had one case dismissed as part of his plea negotiations?
Yes.
And that would have been 21-37108.
Yes, ma'am.
So initially, he was charged with indecency with a child by contact for in 2 cases, same victim, not just one.
I'm objecting. That's relevant. In case it's been dismissed, it shouldn't have any part of this.
It was part of the original plea agreement. That's overruled.
And at this time, what is probation recommending for Mr. Sinnett?
ISF cognitive chat is available for Mr. Sinnett, but I don't think it's appropriate.
I'll pass the witness, Your Honor.
Thank you. Any questions?
Yes, Your Honor. So he actually attended the program, correct?
He did.
And he was kicked out, and you or whoever knew he had an issue with funds to pay for the polygraph, correct?
Yes, he did receive reduced rate of charge with Mr. Simon. He went from $30 to $15. He worked with his budget.
But it is true that Mr. Sinnett said, I don't have the funds and I can't afford to pay it.
He did.
And that's ultimately why he was kicked out of the program. He didn't pay it. And didn't take the polygraph.
Yes.
No further question, Judge.
Just a couple, Your Honor.
Sure, go ahead.
Ms. Simon, is it a requirement of Mr. Sennett's probation that he maintain employment?
Yes, ma'am, but Mr. Sinet does receive disability.
Okay. Pass the witness.
No other questions.
Do you know how much the disability is a month?
It last, I remember it was in the 900s. I don't know if it was changed.
How much do you, raise your right hand? Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, how much do you receive in disability a month?
$1,064.
Okay, and where do you live?
I live in an apartment,
Who pays for that apartment?
$235 a month.
235, so you get housing,
Section 8.
Section 8, so your part of it is 235?
uh,
Your part is 235 of the rent,
Yeah,
okay? And do you also get SNAP benefits or food stamps?
$50 a month.
Okay. Any other benefits that you receive?
Whatever.
Do you have a vehicle?
Yeah, I'm paying 400 and some dollars on my car note.
And do you live with, are you married?
No,
Do you live with someone else?
I live in my own apartment.
Nobody lives with you?
No,
Are the electricity and all of that, is that paid for through the apartment, or do you pay any of
I
that?
pay the light bill.
How much is that about a month?
It runs varies, it's like $70, $80 a month.
You have any other bills?
I had some bills, but my sister helped me out and paid them all, paid them. I had two, a loan,
But you're not paying those anymore?
no. So I'm gonna have to be getting extra money coming in now.
So that's okay. So the polygraph is $15.
No, ma'am, that was the weekly
The
session.
weekly sessions are $15. And how much is the polygraph?
Runs around $250.
And Mr. Sinet has been on probation since February of last year, so a year and a month or so,
Yes, ma'am.
and given time to save up for that, all that time with the two different providers.
He hasn't been attending since he was last discharged. That's when I filed this NTRP. But whenever he discharged from Miss Ayala, I told him to set the funds aside and communicate that with Mr. Simon, so he could pay for one.
Okay. All right, any other questions of Ms. Simon?
No, Your Honor.
Not from the state, Your Honor.
So, any other witnesses with regard to, whether or not counts one and true or, no other witnesses?
No.
So based on that information, and testimony by Ms. Simon, I am going to find counts 1 and 2 true in that motion to revoke unadjudicated probation. I've also we have the updated report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor.
Are there any additions or corrections to that report?
I'm aware of, Judge.
Not from the state.
Mr. Parker, you may proceed.
Your Honor, I think my questions are playing our position. He attended it. It's what he's relayed to me is it's always been an issue with money that he couldn't afford to pay for the polygraph. He told me he thought it was $300 and he just couldn't afford it. And I think he'd like to address the court, Judge.
Go ahead, sir.
I didn't have the 300, I was paying my money and the $25 a week. And then all of a sudden she jumped up and said she would give me 6 months to pay, to save the money up. And all of a sudden she changed her mind And, to the 6 months, it was 3 months or something like that. And I just didn't have the $300. I was paying every, I was going to the therapy. I was paying the $25 a week.
But when you were going to the therapy, you were denying that you had committed the offenses still, correct?
Yes, yes.
Okay.
When I went to the PSI and stuff like that, and then I talked to the.
This is a turning point. The judge is recalling the back and forth, trial, plea, denial, acceptance. That kind of inconsistency can completely damage credibility in court. And once a judge starts questioning your honesty, it's incredibly hard to recover from that.
Probation officer.
Mr. Sinette, so the thing is, I recall all of this because your case went on for so long. Because it was, we're set for trial. No, we're going to plea. We're set for trial. We're going to plea. I did it. I didn't do it. I'm going to take responsibility. I'm not going to take responsibility. So it's not usually a good thing when I recall all of those things because I'm pretty sure we had a jury ready to go. And on the day of trial, last minute, or maybe even after we selected, I can't remember. It was truly at the last minute. You came in front of me, swore under oath, and pled guilty that you did these things. Nobody forced you to do that. I know I went over it at length because of the history of all of this.
Can I say something? My witness was not called, was not being called into trial and stuff. I was coerced into doing what I done.
So the problem with that story is that I was here and I was a part of it. And you had every right to, there's no one asked for, I know your attorney did everything he could. And I know we talked about that witness. I remember some about that. But the other side of that, though, is I told you that day, don't play guilty if you didn't do it. Because you're swearing under oath, which means you lied under oath, is what you're telling me. But I don't believe that. I believe that there is something that happened. You did plead guilty. There's information in here. And so the biggest problem that I have is that you're on probation for a very serious offense that you're saying you didn't do, which means the treatment can't really help you, even if you were to do it, because you're not taking responsibility for what you did. I also believe that over that amount of time with probation working with you, getting you with a provider that charged substantially less, that you had the ability to, over at least the time frame that you were on probation before that motion was filed, to come up with the money for the polygraph, which is required. I've done some math. I know you don't have a lot of money, but you also don't have a substantial number of bills. And had you saved just a little bit each month, you would have been able to pay for that polygraph as required. Anything else, Mr. Parker?
Nothing else.
They gave me.
Hang on.
They gave me 6 months to save my money and stuff like that.
Right.
And then all of a sudden she changed it.
The 3 months.
But then you were with another and you got with Mr. Simon and you still
Okay,
did.
I went with him. He told me, say, Mr. Sinet, you don't have to pay the $15. Go ahead and save the money for your lie detector test. Then all of a sudden he changed his mind and told me that he wanted me to pay the money for the $15.
So, but see, Mr. Sinet, what you're saying is, again, you're putting responsibility on other people. I find it hard to believe that they both just lied to you. That both of these doctors just lied and said, I'm going to give you this. And then all of a sudden they said, nope, never mind. I'm going to kick you out. That they don't work like that.
I think what it was, Judge, is that once he didn't accept responsibility, they say now you're required to take the polygraph. That's why it bumped the time up. That's his story is
Well,
consistent with that.
And that goes back to
Right.
not
I
accepting
understand.
responsibility. So which gets us where we are anyway. So Ms. Argument with regard to any other argument?
Right. I want to keep him on probation. I think the cognitive track would be a great thing for him. I think he was making efforts to do the probation and do the classes, and I think the cognitive track is a perfect thing for him.
Ms. French?
Yes, Your Honor. From the state's perspective, Mr. Sennett pled guilty to a very serious charge. um, A a charge of indecency by contact with a child. A child who was, if I can see quickly here. I'm looking for well, I've lost it. A
14-year-old
child,
family.
regardless.
14-year-old family friend.
Yeah, below the age of 17, 14-year-old family friend. The state, as part of that agreement, dropped another charge. And yet here we are a little over a year later, and now Mr. Sennett is saying, I'm not guilty. I didn't do this. Not taking part in the things that he is required to be active in, the sexual offender training. Had he not continued to deny his guilt, he may not have been asked to take a polygraph test. But either way, we're a year into this with no active participation, no positive participation, and still a denial of guilt for sexual contact and decency by sexual contact with a child. So the state would defer to the court regarding a sentence, but would ask the court to make it one that would continue to protect the children in our community.
Thank you, Ms. French. And so, anything else?
No, Your Honor.
So, Mr. Snett, I'm looking back also at the original pre-sentence report. Obviously, we had the issues of whether or not you accept responsibility, and that was a 10-year cap, which means on that day, against the argument of the state's attorney and against the wishes of the family of the victim in this case, I sentenced you to probation. And I look back and I wonder why I did that, but I was hoping that you would get the help you needed so that I could feel like our community was safe. You refused to do that, or you refused to accept responsibility. So that means you refuse to do all of the other things and take the polygraph and follow through with your sex offender treatment. So at this time, in cause number 21-37107, I'm going to find again counts 1 and 2 true, find sufficient evidence at this time to find you guilty. And at this time, find you guilty of indecency with a child.
And just like that, the sentence is handed down. 15 years. What started as probation, essentially a second chance, has now turned into a long prison term. This is a powerful reminder. Probation isn't freedom, it's a strict agreement. Break it, and the consequences can be even harsher than the original deal.
Going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition will lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. You can go back with the bailiff.
Thank you, Your Honor.
You're Kevin Boyd,
Yes, yeah.
and this is 26 DCCR 0227. Mr. Boyd is charged with driving while intoxicated, third or more. And Mr. Mitchell, what is the announcement?
Judge, we're asking for a little more time. I've spoken with Mr. Smith this morning. I've been out ill, severely ill, so I just need a little more time to get with Mr. Smith in his office.
Any issues? And Mr. Boyd, do you currently have that auto ignition interlock device on your vehicle?
I have a monitor. Oh, my. This is.
Understand, I don't think that's.
You're not trying.
Oh, monitor.
Yeah.
4 hours.
So, did the magistrate give you that? Who told you to get that instead of the auto ignition interlock device?
Where they at them? Where got it? I don't know. 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 I
Okay, so here's the problem is, and I'm running into this, apparently we're having some issues with the magistrates not giving out it's mandatory on a DWI third to have the auto ignition interlock device.
Right.
So. Okay. So that one does say it. So you are required to have that auto ignition interlock device. So you need to change.
Oh, no, we could just put it in the car. If you don't drive that car, you don't drive that car.
You can't drive any vehicle unless it has it. All right,
That's what
so
I'm saying, you want to be a driver.
that's fine. If you don't drive, then you don't have to have it.
Okay.
If you
But-
don't drive, continue doing the device, the breathalyzer type or handheld
Yeah.
device.
Because you're not driving at all, right?
You're not driving now?
I have driven, but not.
Okay, you cannot drive starting today
Okay.
unless you have that auto ignition interlock device on your
Sure.
vehicle. It's a condition of your bond. So it's been a condition of your bond. It shows since you got out. So it's very important that you follow all of those conditions that were placed on that original bond. If you don't, you raise your bond, you go back to jail. Nobody wants that. So make sure you talk to your bondsman. You're clear about all of those
Okay.
conditions. They can't change a condition that the magistrate ordered or that's required by law. So make sure, I don't know if,
I don't know if it was the provider that gave it to him.
yeah, the providers, where'd you get the handheld?
Johnny.
Johnny's?
Yeah.
Make a note for me to make sure they're not making that. Okay, all right.
So I need to monitor. it.
Yes.
Still.
If you don't,
only
if you
drive.
are not driving,
No, I'm not talking, no, talking about.
yes, I want you to have something.
Okay.
All right, so
Not-
go ahead and keep that.
No,
If you're not gonna drive, use
Yeah,
every 4 hours. If you are gonna drive, go ahead and get the monitor.
Correct.
right, right.
He's correct.
I
Yeah,
understand.
gotcha. All right, we'll see you back at your next court date.
Thank you.
Give y'all some time to go over it.
Thank you, Your Honor. I
Yes,
appreciate it.
sir. All right, you're free to go. Thank you. Oh, I don't know. Do I know? Good morning, ma'am. Are you Catherine Batista? And this is 25 DCCR 1608, and Ms. Batista is charged with publishing or threatening to publish intimate visual material. And what is the announcement?
Your Honor, we're still completing discovery. Also, I discovered that it looks like it's going to be Luke's case.
We had juggled some cases around, Your Honor. Originally
like-
it was Miss French's, now it's mine.
Okay.
As soon as we review the discovery, I'll request an offer from Mr. Nichols and we'll be prepared to move forward when we come back. I assure you.
Sure. Any issues?
No, Your Honor.
So we'll just do a normal reset. Ms. Bautista, stay in touch with Mr. Paget once he gets all that information and offer from the state. Make sure you visit with him so that we can get an announcement at the next court date. All right, you're free to go. Thank you.
You may be excused.
Good morning, ma'am. Are you Kayla Provost? And this is cause number 25 DCCR 0972. Ms. Provost is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Just we still completing discovery right now, just one reset.
Okay, looks like you were just hired at the end of February. Any issues?
No, Judge, he's picked up the video and requested discovery last week. I
Perfect.
tendered an offer as well.
So, Ms. Provost, I'm going to reset your case about 30 days, normal reset. Make sure you go visit with Mr. Adams. He'll have that video and you guys can watch everything and see what the state has, and then we'll get an announcement at the next court date. All right, you're free to go.
Thank you, Judge.
Thank you, sir.
Appreciate you.
Yes, sir. Ms. French, this is yours on Jeremy Chapman.
Okay. Waiting to hear which.
Good morning. You're Jeremy Chapman,
Yes, sir.
and this is 25 DCCR 1337. Mr. Chapman's charged with solicitation of prostitution. And what is the announcement?
Sir, Your Honor, this is also a objection.
Oh, I'm sorry. There it is right there. Let me go through it. So, Mr. Chapman, what that means, what you're charged with is the state jail felony, which means if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes.
And I have here on the tablet plea bargain rejection that you've signed with Mr. Kelly that shows that the state's offered you a 3-year deferred probation with a $300 fine. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, sir.
And do you want to reject that offer and have your case set for trial? And is there any reason, anything that's outstanding discovery or anything like that?
Can't imagine there is Miss French's.
Not that I'm aware.
So what that means, Mr. Chapman, once your case is set on the trial docket, and Mr. Kelly knows that, unless there is new information that either the state or he receives, that I will not accept a plea agreement in that, for that same plea, in your case, unless you guys do something well before trial and give me good cause to do that. Do you understand?
Yes.
All right, then I'll get it set on the trial docket. Mr. Kelly will begin preparation for trial. Thank you.
Thank you.
Mr. Parker, got Ernest Sinnett. Good morning, ma'am. You're Crystal Robertson.
Doesn't have to say.
And this is 25 DCCR 1526. And Ms. Robertson is charged with forging a governmental instrument. And what is the announcement?
I was just repaying on this a little while ago, still
Yeah.
wanting. It's for we set out last.
Any issues? All right, we'll just do a normal reset. That'll give Mr. Burbank some time to get all the discovery from the state and then offer, and we'll see where we get at that next court date. Make sure you stay in touch with him and he'll let you know when you need to be back. You're free to go. And then Kingston Walker, 2 cases, Mr. Burbank. Good morning. Are you Kingston Walker?
Yes.
And this is clause numbers 25 DCCR 0861 and 0862. Mr. Walker's charged with tampering or fabricating physical evidence with intent to impair and possession of a prohibited weapon. And what is the announcement?
Your Honor, I misread state's offer, because it's asking for something that I did not explain to him. I've been
Okay.
out of pocket for about 2
And,
weeks.
and I recognize how busy Mr. Burbank's being judged. I'm not opposed to him, Mr.
Okay, we'll do one more normal reset.
Thank you.
Mr. Walker, make sure you get in touch with Mr. Burbank before that next court date so you can go over everything with him and then we'll get an announcement.
Yeah.
All right, you're free to go.
I had somebody else.
You did. Rakeem Allen, good morning. Are you Thomas Valentino? And Mr. Valentino was previously in court and entered a plea of guilty. Hold on, sorry. In count 1 only of the indictment to the state jail felony offense of theft of material. We reset the case for sentencing to give Mr. Valentino some time to get his affairs in order. And Mr. Valentino, just a couple questions. Have you been arrested for anything since we were here last time? All right. Is there any reason not to go forward with sentencing, Mr. Rojas?
No, Your Honor.
Ms. Malfino?
No, Your
All right, then at this time, sir, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You will receive credit.
Wasn't the agreement 16 months?
Had to 18.
Hold on, she'll pull up the paperwork
I was 16.
18.
on the plea agreement that y'all signed, everybody signed.
Okay. Can I have them all?
Sure. Yeah, because that's the plea.
That is the plea paper, but okay.
Okay, I'll hold it for just a minute. Y'all just stay here in the courtroom, please.